this language now, after much debate in the subcommittee, will bring into existence that it will give the right for an individual to be able to pray and participate in the prayer or other religious activities, and ensure that the Commonwealth will not be able to coerce or encourage any type of prayer on public property. This allows each individual to be able to express themselves in accordance to what their beliefs and what their conscience is, and it will ensure that those rights are afforded to every individual in the Commonwealth, plus protect each individual from the Commonwealth to establish any type of prayer.
But I want to ask a question on line 42. After the word schools, shall be, essentially says that no student in the public schools shall be compelled to perform or participate in academic assignments or educational presentations that violate his religious beliefs. Mr. Chairman, I happen to be one of those that believe that the book of Genesis actually confirms the Big Bang Theory, but that's another matter. With this, if someone didn't believe that and had to study the Big Bang Theory in science class, and that was against their religious beliefs, would they be able to opt out of that chapter?
And in this regard, as already children of faith who are taught in school, this is a theory. We have both theories which are referenced in educational programs throughout the Commonwealth of Virginia. Theories are just that. Theories are that which a student is free to consider and to reject after much thought and process about it. No one is compelling anyone to believe in the Big Bang Theory or creationism, one or the other.
Mr. Chairman,
Senator McEachin.
That's not what it says, William. William? And you may call me Aston if you want. William?
I mean, what was the second syllable?
Ton.
Oh.
William, it says right here, shall be compelled to perform or participate in academic assignments or educational presentations that violate his religious beliefs.
Right.
So if he doesn't believe in the Big Bang, because he believes the strict construction of Genesis says that there is no such thing as the Big Bang, would that student then be able to, like, you know what, I'm not taking the test on the Big Bang. I'm not going to read that chapter on the Big Bang. I don't want to take the field trip to the Guthrie Center to learn about the Big Bang.
Mr. Chairman and Senator McEachin, Aston.
Thank you.
I would say this, Mr. Chairman, in those types, I'm certainly one that believes in creation, but I learned about the Big Bang Theory, and it was something that, of my free will was able to determine myself. But this, if I was able to boil this down for you, Senator, there would be Muslims. This is not specific to one religion over another. This is to all faiths. But a Muslim who would object to any operating on a fetal pig, because that Muslim believes that in his faith that it is an unclean animal and should not touch it, he or she, then that would be applicable. But to say that this clause would give any student the ability to say, well, doing homework violates my religious beliefs, is, as I think everybody knows better than that.
Our review of the bill is that facially it is constitutional. It is the constitutional amendment is essentially an acknowledgement of the state's ability to accommodate the free expression of religion of its citizens without establishing a religion which would be the only conceivable way it could violate the United States Constitution. We don't believe it violates the Constitution. The distinction I would draw to the example that Senator McEachin made is that what this does, if a student was asked describe the Big Bang Theory of the creation of the universe, that would be a legitimate question. You wouldn't be able to opt out of answering the question. However, the student could be downgraded for putting either the beginning or the end of his answer. Of course, I disagree with all of this. I believe that the earth was created in 6 days and on the seventh day God rested. However, it would not exempt him from answering the question. Obviously, the action of actually touching the unclean animal or being forced to eat something that your religion prohibits you from eating, I don't believe the schools can force you to do that now under the U.S. Constitution, because that would run into a problem. That would be abridging your free exercise rights.
Obviously, the ACLU of Virginia believes that this is unnecessary and unconstitutional and invites litigation. And and is completely unnecessary in some fundamental respects. Either it doesn't do anything, in which case why are we putting code in the Constitution, or what it does do is create a violation of the federal Constitution. But I just wanted to read you a couple of things that are already in your code. There is a Virginia Code 22.1-203.1, which protects the right of student-initiated prayer. Every pupil has some free exercise of religion. There is 22.1-203.2, which sets out that the Attorney General's Office does guidelines for student prayer. There is a provision, specific provision in here, that 22.1-203.3, which says religious viewpoint expression, student expression. Students may express their beliefs about religion in homework, artwork, and other written and oral assignments free from discrimination based on the religious content of their submissions, and on and on. There are literally 30 or 40 different provisions already in our code, many of which reflect what we're trying to move into the Constitution. The Constitution is a document which is organic and a broad brush and sets values and principles. And this prescriptive, I mean, I can't tell you how many lawsuits are buried in this language, but I think what's really important is, the ACLU is out there defending these rights all the time. We defended the rights of kids to put the 10 Commandments inside their lockers. We've defended the right of ministers to perform baptisms in a river and public park. We're out there defending these rights, but we also are out there saying that public officials shouldn't be praying in one religion as an official part of their act, that they need to differentiate between solemnizing an event and advancing a particular religious viewpoint. All of the things that are in here are written in new ways with potential new interpretation and go well beyond, in some circumstances, what the First Amendment to the United States Constitution and our own statute of religious freedoms already does. We have a pretty clearly established set of rights here, and we're out there every day protecting those rights. And this is just simply unnecessary and invites litigation, and I promise you there will be some.
And I thank you for that notice. I would point out that just because there are going to be lawsuits doesn't mean something's wrong. And so, thank you.
Mr. Chairman, I think I'm quoting that public officials should not pray in one religion, and I read the Constitution a couple of times. It says Congress shall not make any laws establishing a religion nor prohibiting the free practice thereof. Wouldn't that assertion prohibit the free practice thereof, or are public officials not entitled to constitutional protection?
Public officials are entitled to pray voluntarily, but not as a part of the public act as the entity or body. So when the body convenes, there are some special exceptions for Congress, solemnization, but even your own body, you recognize that while you pray each day, if you prayed every day in one religion, there would be a question raised under the First Amendment whether you were officially establishing a religion for Virginia. So what we firmly believe that everybody has the right to voluntary prayer. Kids can go stand at the flagpole on their school property and pray, but what you can't do is have the principal read the prayer every morning that everybody has to listen to and partake in, that is one religion every day. And so that's the distinction.
So,
thank you.
So, Mr. Chairman, if I understand correctly,
Senator Garrett
shall make no laws establishing a religion nor perhaps prohibiting the free practice thereof except under certain circumstances?
No, I mean, it is in fact well settled precedent at the United States Supreme Court level that when public officials in their public capacities act as the government, they may not act in one religion.
Mr. Chairman, I'm Marco Grimaldo. I'm the president of the Virginia Interfaith Center for Public Policy. We stand in opposition to this bill. In the reading of the substitute, I have similar concerns to some that have already been aired, and so I'll simply say that we're concerned in any piece of legislation that would run the risk of placing one religion over the other. Obviously, we're going to support the rights of individuals, both children and adults, to practice their own religion as they see fit. In this case, we don't believe this bill would help that.
Thank you, Mr. Chairman. My name is Richard Salmon. I'm here on behalf of the Jewish Community Relations Council of Greater Washington, as well as the Richmond Jewish Community Federation and surrounding areas. and we oppose the bill. In short, I would point out that the bill does not clarify the current law and the constitutional parameters of public prayer, but rather completely muddies it. It uses terminology that is inappropriate to an evaluation of prayer issues, such as parameters within the same parameters of free speech. It is not a free speech matter, it's a matter of prayer, which is a separate test altogether with regard to the issue of whether or not it public prayer is broken into 4 different buckets. Basically, you have schools who have legislatures. Legislatures have the smallest amount of control imposed on them, and schools have the greatest. This doesn't make any distinction whatsoever. It is a recipe for a mess. And then finally, the line 48 emphasized the right to the free exercise, which is the terminology used in the Constitution of religious expression, which is not a term used in the Constitution. And there is a distinction between public practice and personal private belief.
Thank you very much. Anything further? Is there a motion? Got a motion made and seconded to report this. Call the roll.
Senator Howell? No. Senator Martin?
Senator Martin. Aye by proxy.
Senator Deeds?
No.
Senator Edwards? Senator McEachin?
No.
Senator Peterson?
No.
Senator Smith?
Aye.
Senator Northam?
No.
Senator Vogel?
Yes.
Senator McWaters?
Yes.
Senator Carrico?
Yes.
Senator Reeves? Senator Garrett?
Aye.
Senator Alexander? Senator Obenshain?
Aye.
8 yes, 7 no. 6 no.
Thank you very much.